Oh, hey there, and happy Friday. Welcome to our live stream. I am Laura Wilkerson, and today we are going to talk about a very important topic. This week seemed over the top with conversations that I had to have regarding end of life and advanced directives. So I want to make sure that you, as a caregiver, are all set on this topic and understand the difference between some of these really important documents so that you can better care for the person that you're caring for and make better medical choices, medical decision making for your loved one or with your loved one. So, what is the definition of these advanced directives? What do these look like? Well, advanced directives are legal documents that allow people to express their wishes about medical care if they are no longer able to communicate. This is to ensure that healthcare providers and family members know exactly what kind of care your person wants in the event that they can't speak to themselves. The two types of common advanced directives are living wills and durable power of attorney for healthcare. A living will, this outlines the medical treatments and life-sustaining measures that your person wants or doesn't want, like resuscitation, mechanical ventilation, or tube feeding in the event that they need that. A durable power of attorney for healthcare, on the other hand, is the person who makes these medical decisions on behalf of the person. So that would be you as the caregiver making the decision for your person if they can no longer do it themselves. So what other types of documents are out there? Well, first, there's something called MOLST and POLST. MOLST stands for Medical Orders for Life-Sustaining Treatment, and POLST stands for Physician Orders for Life-Sustaining Treatment. Both are medical forms. Both are used for people with a chronic illness or a chronic condition, and these forms direct healthcare workers to what they may or may not want as life-sustaining treatment. These forms are great and for people who want to have tube feeding, but they might not want CPR. They might want to be intubated, but they might not want tube feeding. The details on the form need to certainly be discussed with your medical provider and have really good conversation around, I do want this, I don't want that, I want this, I don't want that. So it allows you the freedom to pick and choose what you may or may not want. The DNR, a do not resuscitate form, is also an order from a physician, but what this says specifically is that your person does not want cardiopulmonary resuscitation. So no chest compressions, no ventilation. And this document can actually stand alone because I used to work in the ER, and nobody is going to read a document that is this big, like your living will. No physician, while we're waiting to perform CPR or chest compressions or to intubate somebody, is going to look through a 17-page document to try and figure out what it was that your loved one expressly did not or did want. So a DNR is a very short form. And you can kind of keep a copy with your person at all times. You can keep a copy with yourself. The nice thing about a DNR versus a MOLST and a POLST is that the DNR is more widely recognized. You can take that from state to state, and every state knows exactly what this form is. I personally have already done this sort of in my decision making. I've already said to express to my husband, I do want this, I don't want that. And in the event that I can't speak for myself, this is exactly what I want. I don't think that there is a point in time where it's too soon to be talking about these kind of decision making, medical decision making. But having these documents in place If your loved one is still capable of making these decisions when you're thinking about them, if they are capable of helping, what this does for you is it alleviates that caregiver burden, that caregiver strain, and maybe even a little bit of that caregiver guilt if your person expresses what it is that they do or do not want as far as life-sustaining efforts. So how do you get these documents in place? Well, number one, you start that conversation. You start talking with your person if they're able. You start discussing the different forms of life-sustaining treatment, maybe even a couple of different scenarios and how that looks, and then talk to your loved one about, do you want this or do you want that? Once the two of you have come up with a plan, then you need to go visit a healthcare provider. Talk to your healthcare provider. They may have the necessary forms, but you can download those. If you need those, drop the words forms below, and I will make sure to send you a link where you can find those forms to take to your medical visit. For living wills and for powers of healthcare attorney, that's something that you're going to want to consult with an attorney for. And then remember, just because you have these documents in place once, like I think I filled mine out with my husband probably over 10 years ago or so, no, 7, 8 years ago, you want to make sure that you update those, because as you or your person change, or as conditions change, or family members change, you're going to want to make sure that you keep those documents up to date. So just to recap, advanced directives are MOLST and POLST, a do not resuscitate, and how you get these documents in place is you start to have that good conversation. You start to create scenarios around what ifs, and you and your person talk about those and determine what they do or do not want. And then from there, you go visit your healthcare provider and make sure that you get those in place. Thanks for watching. If you have any questions, as always, drop them below.